Welcome back and thanks for joining us. Again, we'll continue our discussion and presentations in that case with one topic that has been the center of much debate and discussion, but is kind of underdeveloped also. So I'm very, very glad that I'm joined here today by Dr. Undine von Diemar and Elizabeth Cole von Jones Day, and they'll be talking about the data protection and cybersecurity developments in China. Elizabeth, Undine, thank you for being here, and the floor is yours.
Thank you very much, Rebecca. It's really a great pleasure to be here together with my colleague Elizabeth Cole, who's based in Shanghai and Singapore, and to have the chance to give you an overview about the most recent developments in terms of Chinese cybersecurity and data protection laws. I will be starting, and I will be trying to set the scene, so to speak, to give you an overview. What are the relevant laws, with a focus, of course, on the personal information protection law. Elizabeth will then go into more detail with respect to the transfer, the cross-border transfer requirements applicable, and we really aim to reserve time at the end for your questions. If there is not enough time left, though, we are very happy to answer any questions also per email. So, what are the relevant laws? It started with a cybersecurity law in 2017. That was the first law that actually set out cybersecurity obligations and at the same time also included some data localization requirements. It's applicable to all operators of computer networks, which basically means all companies who have their own company network. Additionally, it applies to so-called critical information infrastructure operators, in short, CIIOs, and imposes heightened cybersecurity requirements in this regard. Most notably, this law also introduced the concept of important data. What are important data? There is, unfortunately, no unified, clear definition of this term in Chinese laws. There's various guidance on this term, and it's basically, and perhaps also deliberately broadly defined as any information that may endanger national security or public interest. On top of the cybersecurity law, 2 years ago, in 2021, the data security law, the DSL, became effective. This law is really aimed at addressing national security concerns and imposes additional cross-border transfer restrictions based on the nature of the data and, again, as mentioned, national security considerations. It covers important data and, in addition, core national data, which hardly can be transferred out of China in any case. The focus of this presentation, though, is the Personal Information Protection Law, the PIPL. This is, I think it's fair to say, a GDPR-inspired legislation when you look at the obligations and also the way in which are penalties imposed, but it also contains quite severe cross-border transfer restrictions, which are going to be really later on the focus of this presentation. I have to make one caveat up front. What we are going to tell you today is really current information as it is now, so to speak, but it is subject to change, and Elizabeth will go into more detail in this respect. But at the end of September, the Chinese government has published for public comment, the so-called provisions for the standardization and promotion of cross-border data flows. What is this about? It basically is a regulation, a draft regulation at this point, that aims to exclude certain transfer cases from the otherwise quite severe transfer restrictions. For example, certain HR data transfers are going to be excluded, or at least it is proposed to exclude them going forward. So at the same time, we think this means that for the remaining transfers, there could be even more scrutiny on part of the Chinese authorities that companies adhere to the requirements. The PIPL, and let me just introduce some key concepts, relates as the GDPR very broadly to all personal information, which means all information related to identified or identifiable natural persons, whereby, similar as under the GDPR, anonymized data are excluded from its scope of applicability. Different from the GDPR, so-called sensitive personal information is not conclusively defined. It's rather an open and risk-based definition that the PIPL uses because it includes any information that once leaked or abused could seriously endanger personal and property safety, and in the various draft measures, only examples of such information are mentioned, such as biometric information, religious belief, and of course, medical and health data. Similar as under the GDPR, there are two types of organizations governed by the PIPL. Most of the obligations are addressed at the personal information handlers, the PI handlers, which is similar to the GDPR and its data controller concept. There are also so-called entrusted parties who process the information on behalf of the data handlers and are therefore similar to data processors under the GDPR. There's even a requirement to enter into a data processing agreement under the PIPL, although this is not as defined and does not include such high requirements as under Article 28 GDPR. The PIPL also knows the concept of extraterritorial applicability. This means it can apply to PI handlers anywhere in the world, provided these PI handlers are processing PI of individuals inside of China, and this PI is used for providing products or services to individuals in China or analyzing their activity. So this might ring a bell because it's pretty similar to the concept that we know from Article 3, Paragraph 2 of the GDPR. Different from the GDPR, though, the PIPL relies on consent as a primary legal basis for handling personal information. There are only limited specific exceptions applicable. For example, when you perform a contract with an individual or fulfill a statutory duty. Also, an exception applies when PI is processed for HR purposes in accordance with work rules. But, and this is really important, there's no legitimate interest exception, so you don't have that flexibility in terms of the legal basis that is available under the GDPR in this regard. Also very important is that separate express consent is required in certain circumstances, and this includes cross-border transfers and sensitive PI processing. So let me quickly run through the main requirements that need to be complied with when you transfer data out of China. And Elizabeth will then follow up with the details. So transferring data out of China first requires informed consent from the individuals. It requires a business necessity of the transfer, the completion of a PI protection impact assessment. This might ring again a bell, because this is something that we also know, and it's somehow related to what we do when we have to undertake a transfer impact assessment required for cross-border transfers under the GDPR. But in addition, also one of the following 4 transfer mechanisms need to be complied with, or those measures need to be implemented. There's first the requirement to undergo a security assessment, which is required for all transfers by the CIIOs. We mentioned those in relation to the cybersecurity law at the beginning of the presentation, and for PI handlers who handle and transfer PI exceeding certain thresholds and volumes of data. Alternatively, under certain circumstances, you can also rely on a standard contract that, different from the GDPR situation, will need to be filed with the local instance of the Chinese Cybersecurity Administration. The other 2 transfer mechanisms, certification by a CAC authorized organization, or the broadly referred to other measures in accordance with law, are at this point not available, so we can ignore them at this point. I want to highlight, though, that cross-border transfers of PI to foreign judicial or law enforcement authorities require prior approval, which is a quite difficult issue in practice. For example, think about a e-discovery scenario in which you would then actually require consent from Chinese governmental authorities prior to transferring the PI. So this requirement, in my view, goes even beyond the requirement that we know from Article 48 of the GDPR, and it mirrors already known provisions from the data security law, but the DSL applies to all data and not just personal information. Elizabeth will now follow up with more details on security assessments and standard contract, and we will, at the end, hopefully have, just checking the time, enough time to discuss your questions.
Thank you, Undine. So as Undine mentioned, this is an area that is really in a state of flux. So I'm going to talk about what the law is as of today, and then talk about how we're anticipating that might change. The most onerous cross-border transfer requirement is the security assessment measures and requirement. And these are set out in the measures on state security assessment of cross-border transfer and related notification guidelines. These came into effect in September last year, and there was a grace period of 6 months, which expired in March 2023, for companies that qualified to file a security assessment. And the security assessment under the current measures is required when a company is a CIO, Critical Information Infrastructure Operator. Under the data security law, if a data handler is transferring this nebulous concept of important data, a security assessment is required. It's also required when a data handler is processing the personal information of more than 1 million data subjects in China, even if that PI is not transferred out of China. So there have been companies we're aware of that have largely processed data in China, consumer companies, but did not meet other thresholds, but because they were processing that million-plus data in China, were subject to a security assessment. The last threshold is a cumulative transfer out of China of personal information of more than 100,000 people, or sensitive personal information of more than 10,000 data subjects since January 1 of the prior year. The security assessment process has been very slow for those companies that have applied. Most companies did not put in their application just because of the sheer detail of the requirements until very close to the end of the grace period. Then, from what we understand, there has been significant review that has occurred both at the local or provincial level, CAC, where the companies have had it reviewed, and then all of the applications had to go up to the central level, CAC, in Beijing. And the applications required not only that there be contracts in place, but a very, very detailed PIPIA impact assessment report, in many cases running to sort of hundreds of pages, going into significant detail on every minutiae of the transfers that were occurring. This has resulted in a massive backlog of applications. It is estimated that probably less than 10% of those applications that are currently in process have actually been approved for a security assessment. So that has been a challenge for those companies that have had to go through that process. The second process, as Dr. Undine mentioned, was the certification process. Although in practice, this has not really been implemented, the current guidelines provide that certification may be used for cross-border processing activities of multinational companies for group processing, or for companies that are outside China and analyzing data of data subjects in China. And this symbol, as you can see on the screen, is the certification symbol. But in practice, there's only ever been one organization authorized to do certification. And as far as we know, it has not implemented any certifications to date. The most common cross-border transfer mechanism for most companies is the standard contract. In February of this year, the government issued the form of standard contract and the measures for filing of the standard contract, and provided for a 6-month grace period to bring the personal information transfers into compliance. These measures provide that any company that is transferring personal information outside of China must use the standard contract with the outbound recipient in the prescribed form, and that there cannot be any conflicting provisions. There's an annex where the parties can supplement the standard contract, but the standard contract itself should not be changed. And once effective, the standard contract must be filed together with a personal information protection assessment with the provincial level CAC within 10 business days after it becomes effective. And that means that from what we have seen so far, that CAC will also require very detailed PIPIA in order to accept the filing. and there are other forms and things that must be concluded in that filing. But the filing process is not simply a case of signing the contract and doing a very simple assessment. It's still a very detailed assessment. The CAC also has a right to, apologies, my auto lights went out, to review and accept the filings within 15 business days and order rectification. And the standard contract requires overseas recipients to notify the handler in China if they receive a request from a foreign government to provide personal information that's transferred under the standard contract. This actually goes further than the provision that we mentioned earlier about requiring approval from the government for any judicial authority or judicial request. And it provides that any request from a government, any authority must be notified to the handler in China, which then creates this dilemma. Is that an official request that then needs to be notified to CIC, or is it just something that the PI handler can sit on? So that has been a lot of the dilemmas that people have been facing with the standard contracts. And we're now less than 2 months away from the effective date when everybody who's supposed to file a standard contract should have filed a standard contract. The reality is that almost nobody has filed a standard contract, and CAC is still trying to complete all of its security assessments, let alone review all of these standard contracts. And there has been huge pushback from companies in China, particularly multinationals, saying this is just too onerous, we cannot comply. And as a result of these factors, just before 2 weeks ago, the CAC issued draft provisions, as mentioned, on the standardization and promotion of cross-border transfer flows. And these, in their current form, propose significant amendments to the cross-border transfer obligations that we just outlined. The first concept that they talk about is that important data, although still not defined, will only be considered important data, or you only need to worry about important data if it's notified by the authority. So if there's a regulation that sets out that this specific type of data is important data, or if an entity is notified by the authorities that what they're processing is important data, then they'll need to treat it in that way. But we've taken away the obligation of the company to try to guess whether or not what they're processing is important data. So that would be significant for a number of companies who feel like maybe we are, maybe we aren't. The second potential exclusion is that if the processing of personal information cross-border is for HR management purposes, so as many companies have multinational global HR management systems, and if the proper consents or work rules are in place, then no security assessment, no standard contract or certification will be required for that cross-border transfer. And the third significant proposed change is that the quantitative threshold for security assessments, standard contracts and certification will be changed. So for a security assessment, it is proposed that only companies that are transferring personal information of more than 1 million people out of China, not just within China, will have to undergo a security assessment. For those who are transferring data of more than 10,000 data subjects within a year, then a standard contract will be required. But if the personal data transfers involve less than 10,000 data subjects, then it is proposed that none of the cross-border transfer mechanisms will be required. In other words, for a company that is processing personal data of less than 10,000 individuals, then they will not have to comply with any of the cross-border transfer requirements. We do anticipate that these draft regulations will be published, maybe not in the exact same form, but close to it, probably before December. And that will take a lot of pressure off a lot of companies that have been subject to these requirements. However, we're not expecting any change to the deadline for compliance for those companies that have to comply. So for those companies that still fall within the requirements for a security assessment, or still have to file a standard contract because they're processing and transferring data of more than 10,000 data subjects, or whatever threshold they finally set, then compliance will be required. All of those items like the PIPIA will be required and needing to be filed. And the onus will be on companies to show that they've been through the process to determine whether or not they need to do this if the CAC comes calling. So there's still going to be a requirement to do a PIPA, and there's still more risk that someone's going to come look at it. But for a lot of companies, these changes will vastly simplify the cross-border transfer process. And so what else are we expecting apart from these changes in cross-border transfer? We're hoping to have more guidance on the consent requirements. It is still an open question whether or not consent is, when you're using an exception to consent for a transfer, whether you still need to get a specific consent. For example, if you're relying on the HR management exception to transfer data out of China, do you then need consent to transfer the data out of China? We're also anticipating more rules on the requirements for data protection officers and how they would be registered, and also data breach notification guidance. There are data breach notification general obligations under the PIPL, but it is not clear who you report to and when you have to do so. And then finally, we're anticipating more industry-specific regulations in areas such as healthcare and finance to align with the PIPL. There are older regulations in these areas, but some of them are conflicting or out of date with respect to how the law is now being interpreted under the PIPL. So we're looking to see updates in those areas. So that, in a nutshell, is what we're expecting, and we're trying to keep this as current as possible.
Thank you very much, Elizabeth. Rebecca, do you have any questions, or are there questions from the audience?
I would very much like to include more questions. Unfortunately, we did run out of time, but as you mentioned at the beginning, you both, of course, are reachable via email and also via the platforms. So the audience, absolutely feel free to reach out to Elizabeth and Undine if you do want to dive deeper into this it is a complex topic and quite dynamic, right? Because the developments haven't been finished yet. So please feel free to do so. And to you both, Elizabeth, Undine, thank you for being here today and for sharing your expertise with us.